This is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude, here for Constitutional Law, Episode 17. And today, we are tackling the Second Amendment, definitely an important one.
Yeah, absolutely. And just so you know, we are bots brought to life by the magic of AI and, of course, Angela's incredible constitutional law notes.
Think of us as your personal study buddies, always ready to help unpack these, well, sometimes pretty complex topics.
Definitely. And if you need to reach out to Angela, maybe share your own study tips or just, say hello, you can email her. It's podcast@studyforthebarinyourcar.com.
She really is the brains behind this whole operation. Angela's put so much work into organizing these notes to make these, dense legal concepts make sense.
Mm-hmm. Actually, if you're looking for even more insights from her, you should check out her interview this month. It's on the website llmguide.com.
Oh, right. What's the article called again?
It's titled 3 Tips for Passing the Bar Exam from George Mason, University of Miami grade. Some really practical stuff in there.
Good to know. And just a reminder for any attorneys listening, if you need a hand with legal research or maybe drafting motions, Angela also does freelance work as a remote law clerk.
That's right. You can reach her for professional assistance at hello@legalwriterandlawclerk.com.
Okay, so today, the Second Amendment.
Mm-hmm.
Few phrases in American law spark quite as much debate, right?
For sure. 19 words. Endless discussion.
Yeah.
And it's critical for con law. Pops up frequently on the bar exam.
Yep. So today, we're going to unpack it. We'll go beyond just reading the text. We'll explore its core protections, how the courts interpret it.
And its maybe surprising connections to other big constitutional ideas, like the Commerce Clause, which, might not seem obvious at first glance.
Exactly. We'll be using Angela's super organized law school notes as our guide, breaking down the key Supreme Court cases.
And we'll throw in some practical bar exam style questions too, just to help you test your understanding and really nail down these concepts.
So whether you're driving, hitting the gym, or just trying to get a solid grasp on this pretty complex topic, get ready. We're going to absorb some essential knowledge.
Vital stuff, not just for the bar, but really for understanding a huge part of American law.
Couldn't agree more. Let's get into it.
All right, let's start where Angela's notes always begin, with the exact wording. The Second Amendment itself, it states,
a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Seems straightforward enough on the surface, doesn't it? But wow, the interpretation has been anything but simple. So much debate over the years.
Absolutely. For a very long time, there was this huge debate.
Right.
Was the right tied only to militia service, a collective right for states?
Or was it an individual right, something everyone possessed, separate from being in a militia?
Exactly. Angela's materials make it clear, though. The Supreme Court has pretty definitively settled this now. The court has firmly established that the Second Amendment protects the right of individuals to keep and bear arms for self-defense. That was a major shift.
So it's not just some abstract idea linked to historical militias. Angela's notes really stress that this individual right specifically includes the ability for a person to keep a handgun at home for security.
Mm-hmm. That feels pretty fundamental, right? Self-defense in your own home.
Yeah, exactly. The ability to have a functional firearm, specifically a handgun, in your home for self-defense. That's like the bedrock principle from the court's decisions here. It's not about hunting or sport, primarily.
It's explicitly about protecting yourself and your family where you live. But, and this is crucial, the right doesn't just stop at your front door.
Right. Angela's outline points this out clearly.
The protection also extends to the right to carry a handgun in public for self-defense.
So it's not confined to your property. It has a public dimension, which I imagine leads to even more complex questions.
Oh, definitely. That public carry aspect was central to some of the really big recent cases we'll get into.
Okay. And the big question that always comes up with federal rights, how does this apply to state and local governments?
Good question. Angela's outline highlights that this right applies to the states through the 14th Amendment's Due Process Clause.
Right. Incorporation. That's a huge concept in con law generally. Can you maybe unpack what incorporation means here, specifically for the Second Amendment?
Sure. So incorporation is basically the legal doctrine the Supreme Court used to make most of the Bill of Rights, which originally only restricted the federal government, applied to state and local governments too.
Okay.
It mainly happens through the 14th Amendment's Due Process Clause. The part that says no state can deprive any person of life, liberty, or property without due process of law.
And liberty includes these fundamental rights.
Exactly. The court has interpreted liberty to include those key rights from the Bill of Rights. So for the Second Amendment, this means state laws, city ordinances, county rules, they all have to respect the Second Amendment just like federal laws do.
Gotcha. So a city handgun ban gets the same constitutional lookover as a federal ban.
Precisely, and that's why these Supreme Court rulings on the Second Amendment have such a huge immediate impact everywhere. They set the standard for everyone.
Makes sense. All right, so that's the core right and how it applies. What about how courts actually review challenges to gun laws? The standard of review.
Right, let's talk about the standard of review because, wow, this area saw a really big shift, and pretty recently, too.
Okay.
So before the 2022 Supreme Court decision in New York State Rifle and Pistol Association, Inc. v. Bruen, we'll just call it Bruen, the standard was, frankly, kind of unsettled. It was inconsistent.
How so?
Well, lots of lower courts were using some form of intermediate scrutiny, where a law gets upheld if it serves an important government interest and is substantially related to achieving it.
Which leaves a lot of room for judges to balance things.
Right.
Weighing public safety against the individual right.
Exactly. It led to different results in different places. But Angela's notes show that Bruen just completely changed that landscape.
Yeah, the Supreme Court decisively rejected using means and scrutiny, that's the umbrella term for strict or intermediate scrutiny, for Second Amendment cases. That seems like a really big deal.
It is a massive deal. It means courts can't just balance the government's interest against the individual's right using those familiar frameworks anymore.
So it's not just a small procedural tweak. It changes the whole analysis.
Absolutely. It's a major departure from how lots of other fundamental rights are looked at. Post-Bruen, the current test is rooted deeply and really exclusively in historical tradition.
Historical tradition. Okay, what does that actually mean in practice?
It means the government can only regulate firearms if the specific regulation is the type of regulation that was historically allowed. It has to be consistent with the nation's historical tradition of firearm regulation.
Wow. So the court basically said, if you want to restrict this right, you have to prove similar restrictions existed and were okay way back when the right was understood.
That's pretty much it. This new test gets rid of that subjective balancing that happened under intermediate scrutiny. It replaces it with a much more rigid historical investigation.
So a state can't just say, this is important for public safety today. They have to connect it to history.
Right. They need to ground the regulation in historical practice.
So just to make sure I'm getting this, courts now have to look for, historical analogs. If a modern gun law doesn't have a historical counterpart from the right time period, it's probably unconstitutional.
That's the essence of it. If a state wants to pass a new gun law, arguing it's crucial for modern safety isn't enough. They actually have to find a historical example of a similar type of regulation being okay back then.
That sounds like an incredibly high bar for new laws.
It is an exceptionally high bar.
Yeah.
And Angela's outline stresses the historical inquiry needs to look closely at evidence from two key periods.
Okay, which ones?
1791, when the Second Amendment was adopted, and 1868, when the 14th Amendment was adopted, which is when incorporation started happening.
So both the original meaning and how it was understood when applied to the states.
Exactly. That dual focus is key. And this historical lens becomes basically the only tool for judging gun laws now. The burden is squarely on the government to prove its law has historical roots.
Not just that it serves a compelling modern interest.
Correct. So, for instance, if a state tried to ban a whole class of firearms common today, they'd need to find a historical equivalent to that kind of broad ban from the late 1700s or mid-1800s, which would be pretty challenging.
Okay, that clarifies the standard. Let's dive into the key Supreme Court cases that really shaped all this. First up, District of Columbia v. Heller from 2008. Monumental case, right?
Absolutely monumental. Angela's materials really detail how Heller established that the Second Amendment protects an individual's right to possess a firearm for traditionally lawful purposes, like self-defense in the home, and crucially, independent of militia service.
So Heller was the case that definitively settled that individual versus collective right debate we talked about earlier.
Yes, exactly. Before Heller, courts and scholars were really split. And the D.C. law involved was incredibly strict. It basically banned handguns in the home.
And didn't it also require other guns to be kept, like disassembled or locked?
Right. Disassembled or bound by a trigger lock, making them useless for immediate self-defense. The court, in an opinion by Justice Scalia, struck down both the handgun ban and that storage requirement.
Because they violated this individual right.
Precisely. The court said the core of the amendment is the operative clause, the right of the people to keep and bear arms. The part about the well-regulated militia, the prefatory clause, just stated a purpose. It didn't limit the right itself.
So that decision totally reshaped Second Amendment law, moving away from the militia focus to individual self-defense.
Completely. A clear departure.
Okay, so Heller nails down the individual right in the home. Then building on that, we get Bruen in 2022. That one further solidified the right, but focused more on carrying firearms outside the home, right?
That's right. Bruen took the Heller principles and applied them directly to public carry. It basically said the right to bear arms doesn't just vanish when you step outside your house.
And Angela's notes highlight it struck down a specific New York law.
Yes. New York required people to show proper cause to get a license to carry a concealed handgun in public.
Proper cause, meaning?
Essentially, you had to prove a special need for self-protection different from the general public, like a specific threat against you.
So it wasn't enough just to want to carry for general self-defense.
Correct. The court said that kind of requirement turns the right into a privilege granted only at the discretion of state officials.
And this is where the court really locked in that historical tradition test we discussed.
Exactly. Bruen is where the court explicitly rejected the balancing tests and said the only way to justify a gun regulation is by showing it's consistent with the historical understanding of the right in 1791 or 1868.
You can really see how that dramatically affects how future gun laws get looked at. No more weighing modern safety concerns against the right in the same way.
Right. It makes it significantly harder for states to justify broad new restrictions. They must find that historical backing. It's a profound shift.
Okay. Now, let's shift gears a bit to a case that's absolutely critical for the bar, but maybe for slightly different reasons. United States v. Lopez from 1995.
Yes, Lopez. Angela's notes really emphasize this one. It's crucial not just for the Second Amendment context, but for understanding the basic limits of federal power, specifically under the Commerce Clause.
This case involved the Gun-Free School Zones Act of 1990, a federal law banning guns near schools. Seems like something Congress would naturally want to do, right? For safety?
Seems intuitive, yeah. But the Supreme Court's ruling was pretty significant, maybe even surprising to some back then, given how broadly the Commerce Clause had been interpreted for decades.
What did they rule?
The court struck down the federal law. The core reason was that Congress didn't have the power under the Commerce Clause to regulate what the court saw as purely local criminal activity.
Wow. That was huge because it was the first time in, 60 years, the court said Congress went too far with the Commerce Clause.
Exactly. It was a major reassertion of federalism, the idea that the federal government has limited enumerated powers and some things are left to the states. It meant Congress couldn't just regulate any social problem by claiming some indirect link to commerce.
And what's fascinating and really key for the bar exam, as Angela notes, is that Lopez is primarily a Commerce Clause case. It's about Congress's power limits, not directly about the Second Amendment right itself.
That distinction is critical. You might see a fact pattern about a federal gun law and your first thought is Second Amendment. But the real issue could be whether Congress even had the authority under the Commerce Clause to pass that law in the first place.
Okay, so to really get Lopez, we need to understand the Commerce Clause powers. Angela's outlines break it down into 3 categories Congress can regulate, right?
Correct. First, Congress can regulate the channels of interstate commerce. Think of these as the pathways.
Like roads, rivers, airways.
Yep.
Roadways, waterways, airways,
Right.
but also think about digital channels now, too. Telecommunications networks, the internet. Congress can regulate things like wire fraud because those digital signals cross state lines using these channels.
Okay, channels. What's the second category?
Second is the instrumentalities of interstate commerce. This means the people and things that actually move through those channels.
So like airplanes, trucks, trains, and the people operating them. Flight attendants, truck drivers.
Exactly. Congress can regulate these instrumentalities to ensure safety, efficiency, things like that. Think federal rules on truck driver hours or airline safety standards.
Got it. Channels, instrumentalities. And the third one, this is the big one for Lopez.
Right. The third and often the most tested area is activities with a substantial effect on interstate commerce. And here, the analysis really hinges on a key distinction Angela's outlines emphasize.
Which is?
Whether the activity Congress is trying to regulate is commercial or non-commercial. This distinction is everything because it determines if Congress can use the aggregation doctrine. Okay, aggregation doctrine, let's unpack that. So if the activity is commercial or economic, like growing crops, manufacturing, workplace stuff related to commerce,
Then Congress can use aggregation. Angela's outlines recall the classic case Wickard v. Filburn. Remember that one?
Vaguely. Farmer growing wheat.
Yeah. A farmer grew wheat just for his own use, on his own farm. Didn't plan to sell it. But the court said even though his little bit of wheat alone didn't affect the market much, if every farmer did that, the cumulative effect, the aggregation, would substantially impact the national wheat market by reducing demand.
So Congress could regulate even his personal wheat growing.
Right. Aggregation lets Congress regulate lots of activities that look purely local individually, but collectively impact the national economy. It's about the big picture.
Okay, and this is the Lopez point, if the activity is purely non-commercial or non-economic.
Then the aggregation doctrine generally cannot be applied, and that's exactly why Lopez came out the way it did.
Because possessing a gun in a school zone was seen as non-commercial.
Exactly. The Supreme Court viewed possessing a gun near a school, or even the broader topic of education, as fundamentally non-commercial, non-economic activity. Since it wasn't commercial, aggregation didn't apply.
And without aggregation, that activity didn't have a substantial effect on interstate commerce that Congress could regulate under that power.
Precisely. The court basically said, look, this is a criminal statute. It has nothing to do with commerce or any economic enterprise. Congress can't just regulate everything under the sun by finding some tiny indirect economic link.
Makes sense. And Angela's materials also mentioned the NFIB v. Sebelius case, the Affordable Care Act one. How does that fit in?
Right. In NFIB, the court said the individual mandate requiring people to buy health insurance was also outside the Commerce Clause power.
Why was that? Buying insurance seems economic.
The reasoning was subtle. The court said Congress can regulate existing economic activity, but it couldn't use the Commerce Clause to compel people to enter into economic activity they weren't already part of. It couldn't force them to buy insurance just so it could then regulate them.
Ah, okay. So Lopez and NFIB both showed the court drawing lines around Congress's Commerce Clause power, especially with non-economic activity or compelling new activity.
Exactly. They reinforce the idea that Congress's power, while broad, isn't unlimited.
Okay, great clarification on Lopez and the Commerce Clause. Now, let's touch on a general principle, the state action requirement.
Yes, fundamental point. Angela's notes make it super clear. For most constitutional rights challenges, including the Second Amendment, you absolutely need to show state action.
Meaning the government has to be involved somehow. Local, state, or federal government action.
That's the threshold. The Constitution generally protects you from the government, not from private individuals or private companies.
So like your boss searching your desk at a private company or a private school having its own rules, those usually aren't constitutional issues.
Generally, no, because there's no state action. The Constitution just doesn't apply to purely private conduct in most cases.
But there are exceptions, right? Angela's notes mention something about a public function.
Right. There are very, very limited cases where private actions can be treated as state action. This happens when the private party is performing a function that is traditionally and exclusively reserved for the government.
Traditionally and exclusively. Sounds narrow. What are the examples?
Angela's outlines give the two main ones the court has recognized. First, operating an entire town, like in Marsh v. Alabama, that company town case.
Oh yeah, where a private company owned everything and acted like the government. I think Angela mentioned that was actually on a bar essay once.
It was, February 2013. Shows it's rare, but still relevant. The other example is conducting an election for public office. Even if a private group runs it, that's seen as an exclusively governmental function.
So running a town or running an election, that's basically it.
Pretty much. Outside of those super narrow exceptions, private conduct isn't state action, and the Constitution doesn't apply. It's a really high bar to meet.
Good to know. Okay, we've covered a lot of doctrine. How about we try applying it with some bar-style questions?
Excellent idea. Let's test that understanding. Ready for the first multiple choice.
Let's do it. Question 1. Heller-Bruen application. A state passes a law banning all handguns for self-defense, even in one's own home. Which Supreme Court case and principle would be most relevant to challenging this law?
Okay, banning all handguns, even at home. The most relevant case here has got to be District of Columbia v. Heller.
Why Heller specifically?
Because Heller is the case that established that core, fundamental, individual right to keep a handgun at home for self-defense. That D.C. law Heller struck down was very similar. It effectively banned handguns in the home.
So even though Bruen expanded the right to public carry and set the historical test, Heller is the direct precedent for the right inside the home.
Exactly. Heller's principle about the right to possess a handgun for self-defense in the home directly applies to challenge this kind of law.
Makes sense. Okay, next question. This one tests the standard of review.
All right. Question 2. Bruen historical tradition. A city ordinance prohibits the sale of all firearms that were not commonly available in 1791. What must the city demonstrate to justify this regulation under current Second Amendment jurisprudence?
Okay, prohibiting guns not common in 1791. Under the current standard, set by Bruen, the city has to demonstrate that this specific regulation is consistent with the nation's historical tradition of firearm regulation.
So what does that mean in practice for this specific law?
It means the city needs to find a historical analog. They need to show evidence from 1791 or 1868 that supports prohibiting entire types of firearms based just on when they became available.
So just saying these guns weren't around then isn't enough.
Right. They need to show a historical tradition of that kind of restriction being accepted back then. If they can't find a clear historical analog for banning guns simply because they're newer than 1791, the law is likely unconstitutional under Bruen. Modern public safety arguments alone won't cut it.
Got it. High bar. Okay, question 3, shifting to Congress's power.
Question 3. Lopez and Commerce Clause. Congress enacts a statute prohibiting the possession of any firearm within 1,000 feet of a public park. If this law is challenged, how would the Supreme Court likely rule based on United States v. Lopez?
Okay, federal law banning guns near parks. Based on Lopez, the Supreme Court would likely strike this down.
Why? What's the reasoning based on Lopez?
Lopez dealt with the Gun-Free School Zones Act. The court said possessing a gun near a school was a non-commercial, non-economic activity, and Congress couldn't regulate it under the Commerce Clause because it didn't substantially affect interstate commerce, especially since you couldn't use aggregation for non-commercial stuff.
So possessing a gun near a park is similar.
Exactly. It's also non-commercial, non-economic activity. Without a clear commercial connection or a substantial economic effect on interstate commerce, Congress likely lacks the power under the Commerce Clause to pass this kind of law. The issue isn't the Second Amendment right itself here, it's Congress's legislative authority.
Crucial distinction. Okay, question 4, back to a foundational principle.
Question 4. State action requirement. A private university, which receives no federal funding, implements a strict policy banning all firearms on its campus. A student challenges this policy under the Second Amendment. Will the student's claim likely succeed?
Private university, no federal funds, bans guns. Will the student's Second Amendment challenge succeed? Likely not.
And why not?
Because of the state action requirement. The Second Amendment restricts government action. A private university, especially one with no federal funding and not performing any exclusive government function, is a private entity.
Not a state actor.
Right. Unless it's doing something like running a town or an election, which banning guns on campus clearly isn't, its actions aren't state action. No state action means no constitutional violation claim under the Second Amendment. The claim fails right at the start.
Okay, makes sense. Last multiple choice. Let's tie it back to incorporation.
Question 5. Incorporation of Second Amendment. A state passes a law requiring permits for carrying firearms openly in public. Which constitutional amendment directly applies the Second Amendment's protections to this state law?
Okay, state law regulating open carry. Which amendment applies the Second Amendment to the state? That would be the 14th Amendment's Due Process Clause.
Explain that connection again briefly.
Sure. The Bill of Rights, including the Second Amendment, originally only applied to the federal government. The 14th Amendment's Due Process Clause is the vehicle the Supreme Court used to incorporate most of those rights, making them applicable against the states, too. So it's the 14th Amendment that makes the Second Amendment binding on state governments.
Got it. Essential link. Okay, now for the big one, a bar exam-style essay question. This really pulls everything together.
Yeah, this is where you use that IRSC framework issue, rule, application, conclusion to show you can analyze a complex scenario. Let's set it up.
Here's the scenario. State X passes a law, the Public Safety Act. It prohibits the public display of firearms, even if they're unloaded and holstered, in any public area. The state cites concerns about recent public disturbances. The law still permits private possession at home.
Okay, state law on public display. What else?
Concurrently, Congress passes the National Youth Protection Act. This federal law bans the sale of semi-automatic rifles to individuals under 21. Congress claims it's using its power to regulate interstate commerce and also to protect young people from violence.
All right, so we have a state law and a federal law to analyze. Let's break it down using IRS. We'll need to identify the constitutional issues for each.
Sounds good. Let's start with the State X law. What's the first issue?
Issue 1. Constitutionality of State X's Public Safety Act, Second Amendment. Is State X's ban on the public display of firearms constitutional under the Second and 14th Amendments?
Okay, issue 1. Now the rule. What legal principles apply?
Rule. The Second Amendment protects an individual's right to keep and bear arms for self-defense, established in Heller for the home, and extended to public carry in Bruen. This right applies to states via the 14th Amendment's Due Process Clause, incorporation. The current test from Bruen is the historical tradition test. A regulation is constitutional only if it aligns with historical regulations from 1791 or 1868. Means and scrutiny is rejected. The government bears the burden of proving historical consistency.
Got it. Now the application. How do we apply that rule to State X's ban on public display?
Application. State X's law bans public display, even holstered and unloaded. While it permits home possession, Heller compliant, the public display ban clearly implicates the right to bear arms in public. Bruen, the key question under Bruen is, does this ban on mere display have a historical analog from 1791 or 1868?
Is display the same as carry for this analysis?
That's part of the question. But more importantly, while history shows regulations on the manner of carry, like in sensitive places or carrying with bad intent or carrying specific dangerous weapons, was there a historical tradition of banning all public display, even passive holstered display, everywhere in public? State X would need strong historical evidence for that specific kind of broad restriction.
And just citing recent disturbances isn't enough under Bruen.
Correct. That's a modern policy reason, not a historical justification. If State X can't find a clear, pervasive historical counterpart to this kind of blanket ban on display from 1791 or 1868, the law likely fails the historical tradition test.
Okay, so the conclusion for issue 1.
Conclusion. State X's Public Safety Act banning public display is likely unconstitutional under the Second Amendment, as interpreted by Bruen, unless the state can provide robust historical evidence showing such a restriction is consistent with the nation's historical tradition of firearm regulation from 1791 or 1868.
Makes sense. Now let's tackle the federal law, the National Youth Protection Act, issue 2.
Issue 2. Constitutionality of the National Youth Protection Act, Commerce Clause Lopez. Does Congress have the authority under the Commerce Clause to ban the sale of semi-automatic rifles to individuals under 21?
All right, rule for issue 2. This brings in Lopez.
Rule. Congress's Commerce Clause power covers 1. Channels of interstate commerce, 2. Instrumentalities of interstate commerce, and 3. Activities with a substantial effect on interstate commerce. For substantial effect, the key is whether the activity is commercial economic or non-commercial non-economic. Lopez. Aggregation applies to commercial activity, Wickard, but generally not to non-commercial activity, Lopez. Congress also cannot compel economic activity, NFIB.
Okay, application. How does that rule apply to banning the sale of rifles to under 21s?
Application. The federal act bans the sale of certain rifles to a specific age group. The critical question is the sale of firearms commercial activity? Unlike mere possession near a school in Lopez, the sale of goods, like rifles, is inherently economic. Firearms are bought and sold in a national market.
So because it's commercial activity,
Congress can likely use the aggregation doctrine. Even if one banned sale doesn't hugely impact interstate commerce, the cumulative effect of all such prohibited sales across the country could be argued to substantially affect the national firearms market.
which makes it different from Lopez's non-commercial possession.
Exactly. And it's also different from NFIB because Congress is regulating an existing commercial activity, selling guns, not forcing people into a new one, buying insurance. Even though the motive might be youth safety, the means regulating commercial sales seems to fall within the Commerce Clause power over economic activity.
All right, so the conclusion for issue 2.
Conclusion. The National Youth Protection Act is likely constitutional under the Commerce Clause because regulating the commercial sale of firearms is regulating economic activity that, in aggregate, substantially affects interstate commerce, distinguishing it from the non-commercial activity in Lopez.
Okay, one last check. The state action requirement, issue 3.
Issue 3, State Action Requirement, Applicability Check. Is state action present for both the state and federal laws? Rule. Constitutional challenges generally require state action by a government entity, federal, state, or local. Private action usually doesn't trigger constitutional scrutiny, barring narrow exceptions like the exclusive public function doctrine.
Application. Pretty straightforward here, right?
Application, yes. State X's Public Safety Act is a law passed by a state legislature, clear state action. The National Youth Protection Act is a federal statute passed by Congress, clear federal government action, no private actors involved whose conduct needs scrutiny.
Conclusion for issue 3.
Conclusion. State action is clearly present for both the state and federal laws, satisfying this threshold requirement for constitutional review.
Excellent walkthrough. That really shows how to connect all the dots.
And that pretty much wraps up our look at the Second Amendment and its connections to federal power and rights. We covered a lot today.
We really did. From the text itself, the shift to individual rights, Heller, Bruen, the crucial Lopez distinction, incorporation, state action. Yeah. Ooh.
And hopefully, those practice questions help solidify things. A huge thank you, as always, to Angela for compiling such fantastic constitutional law notes. They really do make this stuff much more manageable.
Absolutely. They're invaluable. Okay, before we sign off, just a few quick but important housekeeping reminders.
Go ahead.
First, just remember, Angela is a law student, like many of you listening. She's not an expert, hasn't passed the bar yet. This podcast is based on her study materials, part of her journey.
Right. Second, neither Angela nor this podcast, us included, are giving legal advice. Nothing we've said should be taken as legal advice. And, AI, like us, we're a study aid, not a shortcut to passing the bar.
Definitely. Third, please use this podcast to supplement your learning. Don't make it your only study source. Mix it up. Diversity in materials is key.
Good point. Fourth, AI isn't perfect. Sometimes we might make a mistake. Angela tries her best to catch things. But hey, even law students make mistakes sometimes. It's all part of learning.
True that. Fifth, this whole podcast series is an academic, non-commercial project by Angela. Purely educational. It's really a passion project for her.
And finally, number 6, if you are driving right now, please be safe. Focus on the road. Don't cause a tort while you're listening to con law.
Good advice. Stay safe out there, folks.
So one more time, if you want to contact Angela for podcast feedback, it's podcast@studyforthebarinyourcar.com.
And for attorneys needing research or writing help, it's hello@legalwriterandlawclerk.com.
All right. Now, I believe tradition dictates a cheesy Second Amendment joke.
It does indeed. Okay, here it is. Why did the history professor bring a musket to class?
Why did the history professor bring a musket to class?
Because he wanted to exercise his right to bear historical arms.
Oh boy, historical arms. Okay.
Oh, we deliver on the tradition. But on a more serious closing thought, thinking about Bruen and that focus on history, it really makes you wonder, doesn't it?
Wonder what?
How will this historically rooted test grapple with future challenges? Things like new firearms technology or changing societal views on safety. That tension between history and modern reality seems like it will keep shaping the law for a long time.
That's a really interesting point to ponder. The dynamic nature of law versus a fixed historical test. Definitely something to keep thinking about.
Well, we're your AI hosts, Maude.
I'm Claude, signing off.
We'll see you on the next podcast. Thanks for listening.